Hi everyone, Dave Sugden of Evidence at Trial. It's been a little while since I've been able to make some videos. I had 2 trials earlier this year that each lasted a few months, and both trials went well. In the first one, I was defending a harassment and retaliation case, and we were able to obtain a complete defense verdict. And then we had a harassment and retaliation case where we represented the plaintiff and got a great verdict for a very deserving individual. So I thought what I would do is make a couple videos to address some important issues that came up in these trials. This first one has to do with character evidence, specifically what we'll hear being referred to as Me Too evidence. We had the privilege of representing a plaintiff who was sexually harassed and discriminated by her boss. Among the evidence we intended to present was that another witness who was subjected to similar conduct by the same defendant could come forward. In other words, we had a Me Too witness. And as you can probably imagine, the defense worked very hard to exclude the evidence about this Me Too witness. There were motions in limine filed before trial that addressed these issues. And then during trial, there were objections and conferences in chambers during trial as the defense continued to argue for this evidence's exclusion. We were able to get the key evidence before the jury, and having a good handle on the law was super important to ensure the court made the right decision. So let's review it here. When we're talking about Me Too witnesses, what we're really talking about is character evidence. But whenever talking about any evidentiary issue, we want to first remember where we are in the analysis. When we're talking about character evidence, this is potential evidentiary exclusions. In other words, if we're talking about character evidence or hearsay or a privilege or past relevance, we're talking about relevant evidence that, for some reason or another, may be subject to exclusion. This is important to remember because if you're the opponent of certain evidence and it looks like hearsay or it looks like excludable character evidence, don't jump to that issue right away. You first want to always analyze whether or not this evidence is first relevant, because if it's not, the judge has no discretion to let it in. Okay, but with Me Too evidence and the Me Too evidence in our case, it was clearly relevant. We were looking to prove that this defendant engaged in harassing behavior, and we had a third party who experienced similar behavior, similar harassment. But was it excludable character evidence? Let's start with the general rule that excludes character evidence. That is found in California Evidence Code, section 1101A, and in the federal rules 404A1. They both essentially say the same thing, and that is that evidence of a person's character or character trait is not admissible to prove that on a particular occasion the person acted in accordance with the character or trait. Under 1101A, it has language that evidence of a specific instance of conduct cannot be used to prove the person's conduct on a specified occasion. You'll see similar language about specific instances of conduct in Federal Rule 404B1. You'll often hear this referred to as propensity evidence. With the evidence of our Me Too witness, we could not argue that because he harassed this person, that is proof that he harassed our plaintiff. That's classic character evidence and it's inadmissible. However, the general rule has an exception when it comes to specific instances of conduct and how such evidence can be used for a purpose other than propensity. We find this in California Evidence Code section 1101B and in the federal rule 404B2. What these rules state is that evidence that a person committed a crime, civil wrong, or other act may be used to prove some other fact. And as for these other facts, they list them out. Specific acts can be used to prove motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident. In our case, the defendant argued that he wasn't motivated by any sexual or romantic desire when it came to his conduct towards the plaintiff. Instead, he argued that he was simply her friend and he sought nothing more than a mutual friendship. With the Me Too witness, the defendant argued that this relationship with her was different and that it did evolve into a romantic relationship. And while this was the defendant's argument that the two relationships were somehow distinguishable, his conduct towards each woman was remarkably similar. Thus, we argue that, number one, he was pursuing a romantic and sexual relationship with the plaintiff, and number two, the similar conduct he engaged in with respect to this Me Too witness was probative of his romantic and sexual intent. In other words, we were not arguing propensity. We were not arguing that because he harassed the Me Too witness, he must have harassed the plaintiff. Instead, we argued that his conduct toward the Me Too witness was probative of his romantic and sexual motivation and intent towards our plaintiff. Now, if it seems like this is a pretty thin distinction, it's because it is. While the jury instructions certainly outline how a jury should evaluate specific act evidence, that it's probative of things like intent or motive and not for propensity, the admission of such evidence is still incredibly powerful for the plaintiff. So there you have it, folks. Character evidence from our most recent trial. I hope you found this helpful. If you did, hit the like button, subscribe to this channel. If you want to do a really deep dive on these evidentiary issues, check out our online course page at evidenceattrial.com. Thanks for watching.